Good evening, everyone. I hope everybody is doing fine. Before we begin, let's have a quick audio check. So tell me, am I visible? Am I audible to everybody? Is the screen visible? Is the presentation visible? Am I visible? Yes? Good. Okay. Audio visual दोनों है भाई. सुप्रिया ने बोला है AV. Okay, great. Good evening, everybody. Who all are here? Hasika, Supriya, Tanvi, Chahat, Study Wings. Okay, ये कोई है जो कि पंख लगा के उड़ने वाला है अभी. And Tanisha. Okay, a very good evening to everybody. Okay, chalo. So those of you who are veterans to these sessions on miscellaneous law, you are most welcome again. And those of you who are, coming to us for the first time for this session, or to whom who have just come across this video one fine day and they're like wondering what is this, then just a little bit of brief that this whole thing, this whole bundle of sessions which we had done on miscellaneous laws. We as in Clat Possible, me as in Neha, I'm the one who has taken all these sessions on miscellaneous laws. This was a Thursday to Thursday thing. In fact, today is the culmination of all the miscellaneous laws sessions. Okay, so today is the day when we are finally concluding our sessions on miscellaneous laws. International law is the last topic that we are going to do. Okay, so after this, next Thursday when you meet me, there'll be something new which we would be doing, since your exam is just around the corner, quite literally. So अब हम जो करेंगे वो हम exam oriented कुछ उससे कुछ what should we do, what should be done in the last days and things like that, something to that effect. We'll have something like that for you for next Thursday. Yes. Oh, Supriya is telling me this is season finale. Yes, bhai, ye season finale hai. Game of Thrones का season finale जैसा था वैसे ही. Okay. Good evening, Anna. Okay, Study Wings telling me his name is Abhishek. Okay, great. Okay, great. Okay, so you're not just what's that? Red Bull, it gives you wings. Okay, so I know your name now. Good. Okay, so season finale, हाँ थोड़ा सा sad होता है, exciting भी होता है और sad भी होता है ना. That's true, Supriya. It's always a mixed bag. Even I've been enjoying these miscellaneous law sessions, but I realized कि बहुत सब तो exam ही आने वाला है, कितना मैं और पढ़ाती रहूंगी. Let me just hold my horses and let's do something else. ठीक? Yes. Okay. Yes, Hasika, that's a good idea. In fact, what you guys can do is you can drop in ideas in the chat box after the session is over. Whatever in this, under this particular video, just give me ideas as to what you would like to see in the next couple of Thursdays. Like Hasika has given a very good idea that, ma'am, can we do a legal GK revision, important topics for the year? Yes. Okay. No, Hasika, haven't been to the second sample paper as yet. We'll do that. We could also do a sample paper discussion, like the 2 sample papers which has come in. So you guys can give me ideas and, we can see as to what you want, and we can actually do what exactly that you people are looking forward to. Okay? Chalo. That being that, let's begin. So this is like a request, and it's something which would be good for you guys. So if you feel that there's something which you need, which you want to be done in the next Thursday, then do put it in the chat box and we can see. Okay? Chal. So let's begin. And okay, Anna is saying sample paper. Tanvi is also saying, can we discuss sample paper? We could do that. Yeah, that's a brilliant idea. We could do that. Sample paper discussion kar sakte hain hum log. Okay, then let me just see how it works out. And next Thursday, maybe we could have a sample paper discussion or a legal GK, either of the two things. Okay? Chalo, let's begin. And this session today, the season finale, is on international law, right? So international law, last year there was a passage which had come on international law, something which was a little different from what you had studied, I think. But the good part was that it wasn't very difficult. That's one thing which is there when it comes down to questions in CLAT, which are on miscellaneous laws. This is something which is going to be new, okay, but it is not going to be something which is very, very difficult, right? I think the sample papers also must have made you realize this, that even though you do get questions on something which is completely off the grid, something which was not in your radar at all, but still those questions by themselves are generally not very difficult. एक आधा कोई आता है जो bouncer type होता है, but usme bhi you would realize that even if the passage is a little tricky, the questions would be fairly simple. So that is something which you keep in mind. So the reason why I'm telling you this is something which I really want all of you to do, is believe in yourself. The moment you see a passage which is, I won't say difficult, the moment you see a passage which is different from what you have studied, okay, from what you have studied, you do not want it to, give you jitters. You do not want it to, make you feel like, okay, what's happening? I can't handle this. No, that's not something which you do, right? If you see something different, you take it in your stride. Oh, okay, different hai, maza aayega karne mein. Wohi routine hamesha karte hain. Let's see, it's going to be challenging. It's going to be more fun to do, right? So keep that perspective in your mind when you are solving a passage which is of something which is different. Do not dread it, rather enjoy it, and you will actually solve it very, very well then. Take. On that note, let's start with international law. Good evening. Okay, I have some people joining in now. Good evening, Gargi, Priyashi. Chalo, badhiya hai. Ab aage chalte hain. Let's begin. So when you look, when we are talking about international law, quickly tell me, what do you understand by international law? Bhai, sabse pehle mujhe apna point of view batao. I want this coming from you guys as to what do you mean by this concept of international law? What do you understand by it? Quick. Give me a quick answer. What is meant by international law? Right? Yes, Anna, that was there, and it was fairly simple. Okay, Chahat is telling me that governs external affairs or international trade. Law that is not nation specific but globally accepted, generally not binding in nature. Okay, that's Anna telling me. Supriya saying laws governing relations, but it is not binding. Law of nations. Study Wings is saying it is law of nations. Now, the thing is that I would not say any of you are wrong, but all of you are okay. Tanvi saying something which is applicable in all countries and ICJ. Now that becomes a little too wide, to say something that is applicable in all countries. Because end of the day, when we talk about nations, if you look at the concept of nations, what are nations? Nations are supposed to be sovereign, right? So do you think if you say something like this, that something which is applicable on all countries, would that be correct? No, right? Since all nation states, मतलब जब हम इंटरनेशनल लॉ में बात करते हैं तो कई बार हम स्टेट्स बोलते हैं, कई बार हम नेशन स्टेट्स बोलते हैं. दोज आर द टर्म्स व्हिच आर नॉर्मली यूज्ड. कंट्रीज जो है वो बहुत ही एक कलोकियल टाइप का टर्म होता है, बट लीगली when we use the term nation states, right? So when you look at nation states are all sovereign. सबकी अपनी sovereignty होती है. So you can't really say that international law is going to be applicable on all of them, right? Why? Because जब हमने constitution भी पढ़ा था, हमने preamble में बोला था कि हमारी country क्या है? Sovereign है. Which means that we are not going to be under anybody's rule, which means we will decide which law is going to apply to us and which is not going to apply to us, right? So even when you talk about international laws which are going to govern your relationship with other countries, okay, that is why traditionally जो आपका इंटरनेशनल लॉ को ट्रेडिशनली बोला जाता था that it is supposed to be a law of nations. It's supposed to be law of nations. Why? Because the subjects of international law were only considered to be nation states. कि भाई जो nation states हैं वो आपके subjects हैं international law के, therefore it was known as law of nations, right? So study wings, Abhishek ne mujhe bola tha bhai ma'am law of nations hai, you are correct, but that's a limited definition of international law. International law is much wider. One is that it is talking about, it's a collection of laws which is going to govern activities which are between countries, right? So as a nation state, when you are dealing with another nation state, that is going to be international law, right? But instead of merely being vis-a-vis one country to the other, now international law has been given a wider interpretation. So here it means that it is going to be international organizations are going to be included in it. Individuals also are in certain ways included within the domain of international law. So it's kind of wider when you look at the concept of international law. I think all of you, whatever you have written, are quite correct. And especially I like the fact that all of you have the feeling कि भाई binding नहीं होना चाहिए. Is international law not binding at all? Do you think international law is not binding at all? If it is not binding, then what is the purpose of it being a law? Right? So that's the biggest question, or that's the biggest irony of international law, right? That since it is supposed to be a law, but you can't really make it binding because each country is sovereign. That's why we say that this entire concept of international law is based on this one very, very important principle. That is known as pacta sunt servanda, right? Pacta sunt servanda means agreements would be kept. So this is like that each and every country, each and every nation state would be, it's like almost like having a good faith. कि भाई अगर आपने agree करा है, if you have agreed to something, then you would abide by it, right? Then you are going to be abiding by it, because that is what international law is based on. It is based upon the amount of trust and good faith that each country is putting in. Because unlike domestic laws, जिसको domestic laws को normally international law concept में हम बोलते हैं municipal laws, ठीक है? इंटरनेशनल लॉ के कॉन्टेक्स्ट में जब हम डोमेस्टिक लॉज की बात करते हैं, द टर्म्स विच इज यूज्ड इज नोन एज म्युनिसिपल लॉज, राइट? तो जो आपके म्युनिसिपल लॉज हैं वो अगर आप नहीं मानोगे, then there is always an enforcement machinery in place, right? The police is there or the courts are there. There is a legal system in place that, okay, if you jump the red light, then there is going to be a police fellow who's going to be standing across to make you stop, and he's going to ensure कि आपको 4,000, 5,000, 10,000 का चालान काट के हाथ में दे देगा, and you'll be bound to pay that money, because if you do not pay that money, you'll actually end up in the jail. But that is not so with international law, because the enforcement machinery is not strong when it comes to international law. अगर करवाना ही है enforce, so normally how do you think it is enforced, international law? Because everybody is telling me here it is not binding, it depends upon countries. So let's say I do not do my part of the deal as per an international agreement, then what happens? Then what is going to happen? Now I hear the word sanctions, right? If that doesn't happen, then you have sanctions, then you have embargoes, right? You have trade sanctions, economic sanctions, कि भाई इस country से trade नहीं करेंगे, export जो है, import जो है वो बंद हो जाएगा, export जो है बंद हो जाएगा. There will be no international trade which would be there, right? You have sanctions which are generally economic in nature. Sometimes you have military sanctions also, which are frowned upon, but they do take place at times, right? So you do have sanctions which are there, but these are imposed very rarely, right? These are not imposed readily. These are supposed to be imposed rarely. And and as a sports sanction also, yes. So that's like some sort of a soft sanction कि भाई आपकी country के साथ हम game नहीं खेलेंगे, आपने गलत किया है, right? So that's a sports sanction also, yes. So, but what is generally seen is, unlike municipal laws, the enforcement of international law is difficult. Hence, this principle, pacta sunt servanda, that agreements would be kept, is something which is very, 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 very crucial when it comes down to international law, right? So international law, this is good. It's a system of law working outside the legal framework of a particular state, right? So it is not law regarding a particular state, rather law which governs something which is outside a relationship, which is outside your nation state also. So it could be with another nation state, it could be with another individual, it could be with another international organization, right? So that is your basic idea. अब नेक्स्ट आता है एक कॉन्सेप्ट कि जो इंटरनेशनल लॉ है ये दो चीज में डिवाइडेड होता है. वन, यू हैव पब्लिक इंटरनेशनल लॉ एंड द अदर यू हैव प्राइवेट इंटरनेशनल लॉ. Can anybody tell me what is the difference between public and private international law? Both are international law, but they're generally a very broad division which is there: public international law and private international law. Yes, can anybody tell me what is public international law or private international law? What is the difference between the two? Yes. Public international law, Supri is telling me, is between countries. So what is generally, also if it's between two nation states, then it is going to be public international law. Okay. And private international law would be between different international companies. Okay, so it could be any other kind of a, not states, but any other entity. So I believe that's what you're trying to say. Very good. Because when you look at the concept of national law, you're very, very close to what we are saying. So when you talk of public international law is what is commonly referred to as international law. You know, if you use the word international law anywhere loosely, then the kind of international law that you're talking of is always going to be public international law. Okay, because this is what we are talking about. This is where you have this is the law which governs relationship between nation states and international institutions, right? So any kind of international institutions, any kind of nation states, the law which governs them is the law of public international law, right? So अगर commonly international law के नाम से हम जब भी बात करते तो हम public international law की बात ही करते हैं. On the other hand, when you look at private international law, this is what deals with relationship between citizens or private entities. So what Supriya was saying, that, you know, there are two companies. So let's say there's an Indian company and it enters into a contract with a British company. So here, if there is some dispute which arises, this would come under the domain of private international law, because here what is getting affected are not two nation states or not two international institutions. Rather, it is going to be two private entities or citizens who are having a dispute. Now, in this case, what actually is the main bone of contention is what is the law, or where is the jurisdiction, which court is going to hear your matter, what are the laws that are going to be applicable to you. That is why private international law is very correctly also known as conflict of laws. Because here in private international law, you have to try to decide कि भाई ब्रिटेन की लॉ लगेगा या इंडिया का लॉ लगेगा. कोर्ट्स, इंडिया के कोर्ट्स डिसीजन देंगे या ब्रिटेन के कोर्ट्स डिसीजन देंगे, ये jurisdiction कहाँ का होगा, right? So all this is going to be decided in when you are looking at private international law. So another name for private international law is also conflict of laws. ये private nature के जो disputes हैं उनके ऊपर apply करेगा. Yes, like okay, Hasika saying like Tata and Starbucks. Yes, very, very true. So not only entity, you know, not only companies, but even individuals. You know, if you're looking at two people who want to file a case of divorce, right? So if there's a divorce case going on between a person who might be a citizen of, let's say, Germany, and the other person is a citizen of India, right? They got married and all, and now they're applying for divorce. Maybe for a while they stayed in India, then for a while they stayed in Germany, for a while they stayed in America. So now which law would apply? Where can they file for divorce? Right? So all those would also come within the domain of private international law. Similarly, any kind of property dispute, right? So anything which has a international flavor to it, but the dispute or whatever is in question, the dispute in question here is of private nature, then would come under private international law. On the other hand, public international law would be when you're talking about nation states. But this is also a traditional outlook. That is why अभी मुझे अभिषेक ने बताया था भाई law of nations. Law of nations होता है public international law. And here there's this word which is used as a concept, which is used, doctrine, which is known as jus gentium. Now, jus gentium basically is talking about what is known as law of nations. That public international law only deals with relations between two nation states. This was the traditional view, because in the modern context, this is something which has changed. There is more to it now. Now, even international institutions, international organizations, they have come within the purview of public international law, right? So, वो थोड़ा सा wider हो गया है context when it comes down to international law. Okay? So here, okay, public international law. There's this one example I've given is of Kyoto Protocol. Kyoto Protocol कौन सा है वो? Greenhouse emissions वाला, right? So the greenhouse emissions, that there has to be some sort of a reduction. So for this, what has happened? There are a lot of countries who are a part of this Kyoto Protocol. So in effect, when you are becoming a signatory to an international protocol, what are you doing? You are agreeing. जो वहाँ पे you are agreeing to, follow whatever has been held within that agreement, right? So whatever is in that agreement, you are agreeing that, okay, we are going to abide by it. So even though you are sovereign, you are now using that sovereignty to show that, fine, we are agreeable to be a part of this deal, right? So therefore, that's your example of a public international law, right? Okay, so let's move on from here. अब आता है नेक्स्ट कॉन्सेप्ट जो आता है इंटरनेशनल लॉ में इंपॉर्टेंट, वो होता है आपका सोर्सेज ऑफ इंटरनेशनल लॉ, right? Because international law is very wide as to now what should be the sources, which source is more important, which source is less important. So we have this statute of International Court of Justice. Now this is generally taken as one of the main stock statutes जो कि आपको international law के sources बताता है, right? So you have this statute of International Court of Justice in 1945 का statute है. This is the statute which established the ICJ, right? ICJ का establishment हुआ था under this statute, and Article 38 of this statute is telling us what are the sources of international law. ठीक, अब आया कहाँ से आपका इंटरनेशनल लॉ? तो सबसे पहला सोर्स, the first source that talks about is international conventions. Now, when you are talking about conventions here, conventions means any kind of written document, right? When you are talking about the term conventions, conventions means any kind of written, signed, ratified conventions, right? So here, if a particular nation state agrees in writing to be governed by certain terms or conditions, then that will become a source of international law and will be bound by it. So when you are talking of convention, treaties would be a part of it. Treaties means like you have contracts between two individuals. जो हम contract law में पढ़ते हैं, contract है two individuals के बीच में. Similarly, if it is a contract between two nation states, right? अगर इंडिया का कोई कॉन्ट्रैक्ट होता है किसी भी फॉरेन कंट्री के साथ, then that will become an international treaty, right? So international convention could mean a treaty between, which could be a bilateral treaty between two countries. It could be, a multilateral treaty between a lot of countries. It could be a convention It could be a protocol. Like, if you remember, when we were doing intellectual property rights, IPR कर रहे थे, तो हम हर IPR में जब कर रहे थे, जो आप चाहे patent को देखो, there is a patent cooperation treaty. When you talk of copyrights, there is a different treaty. When you talk of trademarks, तो वहाँ पे Madrid protocol था. So all those treaties and conventions, what were they? They were nothing but a source of international law, which means that if you do not abide by what you're supposed to do, let's say like India, I'm again going to the IPR example because that is something which we have studied intensively. So if you remember correctly, when we studied the domestic laws on intellectual property, remember we had studied that we have made so many amendments to our country's laws. In fact, just in geographical indications, if you remember, we never had any law on geographical indications. We came up with a law. Why? Because it was our obligation under international law, right? So we had entered into a treaty and we had to create a law for that, right? So that is how important international conventions are. They become binding on a country. So that is one source of international law. So it could be treaties, individual, multilateral, it could be conventions, protocols, any of these kind of things would all be considered as conventions. That is one. Second is when you're looking at international customs. Now, these international customs are unwritten rules. So whatever have been being followed for over a long period of time, then they become binding on all states. Now, what are they basically based on? They are based on uniform practice, state practice. So if you want to, claim that this is an international custom, then you'll have to prove these two things. You'll have to prove that there has been almost a virtually uniform practice over a period of time कि भाई ये custom, ये tradition है, ये over a period of time follow किया गया है. B, it says, believe that such practice is a legal obligation. As in, not only is it that it is a uniform practice कि भाई आप practice करते आ रहे हो इतने time से तो इसीलिए वो custom बन गया, नहीं. More important is also the fact that you are doing it because it is opinio juris. Opinio juris means that the nation states who have been following that customs really feel that they're doing it because it is something which they're legally bound to do. Right? So that's where it is known as, it is a legal obligation. Right? So it's not just something which is out of habit, but they really believe that they are legally obligated to do. Right? So here again, this is another important source of international law. So customs which have been used over a period of time. Okay? So that's your second source of international law. Now, the next source of international law is what is known as the general principles of law recognized by civilized nations. Now here, when you're talking about general principles, this is also known as the concept of jus cogens. Okay, jus cogens is what is known as something which are considered to be, preemptory norms, some things which are supposed to be very, very normal, some things which are supposed to be used by countries normally. Like, so like, for example, when you are talking about like the example given here, it says principles contained in United Nations are that prohibit use of force except in self-defense. So these are supposed to be preemptory. Preemptory norms means that something which is already there, something which nobody has to be told about. They are something which are so commonly used that it is presumed that you would know and you would be abiding by them. Right? So those are your general principles. And in addition to general principles which are of international law, even general principles which are normal, it's something like you have the principles of natural justice. I'm sure all of you remember the principles of natural justice. Can you quickly tell me principles of natural justice? Yes, Supriya, like human rights. Human rights, something which are, something which is very, very basic. So something like natural justice, something like human rights. Quickly tell me natural justice. to be heard, no bias, reasoned decisions, right? All those are principles of natural justice को हम ऑडी ऑल्टरम पार्टम बोलते हैं, right? So that you have the, everybody has the right to be heard. So those are certain very, very basic general principles of law which are given recognition, even though उसके लिए कोई आपके पास treaty नहीं है, कोई convention नहीं है, but then those things are considered to be a part of, this entire package of general principles, right? So even concepts like double jeopardy, concepts like res judicata, कि भाई एक बार डिसीजन जो हो गया वो फाइनल है, आप दोबारा से केस नहीं कर सकते, all those things, basic very basic principles which are considered as general principles. Okay, though obviously things जो बहुत ही basic हैं which are generally followed everywhere, that is fine, there is no problem with those, but there are certain rules जहाँ पे there might be a debate कि भाई ये जिसको जिन है या नहीं, is it something which is so important, which is presumed to be there or not, right? Anna, they are different from, okay, Anna is asking that how are they different from international customs? But international customs, I am talking about vis-a-vis that particular dispute which has arisen. What is the custom in place, right? So custom is specific to the particular dispute which has arisen, to the particular fact situation. Like for example, if there is a dispute between two nations on let's say on trade, like कोई trade का dispute चल रहा है, and it has been happening that for the past, let's say 20 for 100 odd years, the trade had been going on in a particular manner, that let's say there was a 30 days credit period which was always given. So it becomes something which was a custom. So here, when you talk about something which is becoming a custom, which in turn takes the form of law, you are talking about a specific situation, right? So you are talking about that in this specific situation, this is what has been followed over a period of time. So it is a custom, right? So this is going to be very, very specific. On the other hand, general principles are not like this. Here they are more, as the name suggests, they are more general in nature. They are not specific to a type of dispute which might have arisen. They are not specific to a type of interaction which is there, right? So that is why the customs being followed are different, and general principles are more general nature. They are applicable across the board on different things. Okay? I hope it's clear, Anna. Okay. अगली बात क्या आती है? Last thing here, which is given under, इसका भी actually 38 clause 1 and clause 2 है. तुम लोग को आर्टिकल्स याद करने की जरूरत नहीं होती है, but just to make you understand, I am giving you the difference. जो अभी तक हमने पढ़े हैं 3 and ये चौथा जो है, these are supposed to be under article 38 clause 1. ठीक है? अब ये last जो है ये क्या बोलता है? That judicial decisions and teachings of highly qualified publicists. So if there have been some very learned legal minds, people who have been published a lot, people who are known for their legal acumen, if there are these legal jurists, basically, if these people have said something on a particular topic, that might be taken as a source of international law. If there are some judicial decisions which are made, they may be taken as a source of international law. But these are something which are not really binding in nature, right? So that is why they are known as subsidiary means. They are not the primary means, but they are subsidiary means. If the case arises, then they might use it in interpreting it. Right, in interpreting and developing the rules. They are not really proper sources, but they help in interpreting a particular situation, right? एक important चीज हमेशा याद रखना, that in international law, doctrine of precedent या stare decisis, doctrine of precedent, also known as stare decisis, is not applicable in international law, which means that unlike domestic laws, हमारे यहाँ क्या होता है? We say that we have the concept of precedent, which means if Supreme Court has said something, this decision becomes binding on all the lower judiciary, right? The lower courts, they are going to be bound by whatever has been said by the Supreme Court. But that is not so when it comes down to international law. So maybe in one particular case, the ICJ has given a decision on a particular matter. Now, there's another similar matter which comes before the ICJ. Are they going to be bound by the decision which they had given earlier? Would they be bound by the decision that they had given earlier? Say there was a decision between USA and USA versus, let's say there was a decision between USA versus Canada. Okay. Now on a similar point, there is now another case between UK versus Australia on a similar point. So the decision given in USA versus Canada, would this be binding on the second court, on the second decision between UK versus Australia? Would it be binding? Yes or no? It would not be binding, because in international law, doctrine of precedent does not apply. So in effect, if you see कि भैया judicial decisions को आप एक source of law ले रहे हो, but doctrine of precedent does not apply. Now this is kind of contradictory to each other. That is why जहाँ पे ये चीज लिखी है कि judicial decisions are a source of international law, वहाँ पे ये दिया भी हुआ है that but it is subject to this concept of doctrine of precedent not being applicable. Right? तो ये अब कोर्ट के ऊपर डिपेंड करेगा when they're hearing the matter, if they feel that this earlier judicial decision is going to help them in interpretation, they can take that help, but it is not going to be binding. Right? तो जैसे हम अपने municipal laws पढ़ते हुए करते हैं ना, Supreme Court के जब हम when we are talking about the binding nature, we are saying what does it have? It only has persuasive value. Right? It will only have persuasive value, not binding. ठीक है, not binding, only persuasive value. ठीक, अच्छा ये सब था आपका like I was saying Article 38 Clause 1. उसके बाद एक और चीज दी हुई है which is in Article 38 Clause 2. There's a separate clause for that which says about ex aqua et bono. Now what does this mean? It means that in justice and good faith, for the sake of justice, in order to achieve justice and in good faith, if the parties agree to, then there can be something which can be taken as law, which is in addition to all of these. Right? तो 1, 2, 3, 4 जो आपके ऊपर sources दिए हुए हैं, उसके अलावा भी अगर लगता है कोर्ट को that in order to give justice in good faith, कोर्ट को लगता है कि भाई यहाँ पे हमें कुछ और भी we can take as a source of international law, then the court does have the discretion to include something else also as a source of international law. But of course, since it is international law, therefore there has to be an agreement by the parties. So it cannot be that one of the parties feels that okay, this thing should be a source and it should be used to give the decision. But if the other party does not agree to it, then it cannot be used as a basis for giving decision. Right? So ये एक यहाँ पे this factor is always going to be there in international law कि भाई ये जो है ये आपके consent के ऊपर based है. अगर आपने consent नहीं करा है, then it is not going to be binding. Right? So this in fact makes it wider. Right? So this makes it wider कि भाई जो sources of international law है वो सिर्फ ऊपर 4 ही नहीं है, उसके अलावा कोई additional source भी आप इसमें add कर सकते हैं. So it kind of gives that leeway to the court in order to do justice and in good faith. ठीक? This much is clear. This is so far as the sources of international law is concerned. I hope this is clear. Yes, can I see a thumbs up? Can I see a yes in the chat box so that I know that you guys are alive and kicking and understanding what we are doing? Yes. I see a yes coming. Okay, great. Thanks, Anna. Okay, Chahat is also telling me that she's understanding. Great. Okay, चलो. अब हम करेंगे जो पिछले साल आपके एग्जाम में आया था. क्या आया था? There were these theories of international law which had come. One is the theory of monoism and the other is the theory of duism. See, Hasika, it is not that the decisions are not binding. Decisions, see, end of the day, there is something called good faith. That is why when I started off with international law, I told you that one of the first and the most important things which is there in case of international law is that it is based on good faith. That if we are entering into an agreement, then we will abide by it in good faith, right? So that good faith is something which keeps everything going, because otherwise we are all sovereign nations. If you start saying that, what is the purpose if they are not binding, right? If you want to make them binding, in effect, what you are doing is you are taking the sovereignty of a country. So is it a good idea to take the sovereignty of a country away in order to make the decision binding? Do you think that's a very good idea? Of course not. Right? Sovereignty is something which is one of the most sought after and premium assets that a country has. So you can't take away the sovereign. That is why this in the entire concept of international law is very tricky, and there's it's very difficult to maintain that balance. That is why you do have conflict-ridden. You do have conflicts which are there. I'm like, Russia and Ukraine is a prime example of that. Right? When it all began, everybody was like, whether it's even going to start or not, and now there is no end in sight. Right? So things like that's why international law is what it is. Okay, chalo, any which ways. Let's start with the monoism and dualism. Yes, exactly. That is what international law is. Anna's put it very beautifully. I'll just read it out. It says, it is the best we can achieve. International law is the best we can achieve in terms of world cooperation without violating sovereignty of nations. Ye to ekdam Miss India type answer tha, Miss Universe type answer tha. Very nice. So actually, because that's what it is. That's the best thing. Because otherwise, if there are no rules and regulations governing international relations, then you can imagine the chaos which would be reigning, right? We would be back to the barbaric times when anybody who wanted just attacked, looted us and went away, right? And not just India, it was everywhere. Like if you've read about history of Europe, they were all nothing but tribes which were fighting against each other. So it's only in civil that we have this concept of international law which has come in, which are trying to maintain peace. So that is why we had the League of Nations after the First World War, and after the Second World War, we came up with the United Nations, with the UN, right, to ensure कि भाई peace जो है थोड़ा बहुत तो maintained रहे. थोड़ा बहुत conflict तो रहेगा ही रहेगा. We are not a utopian world की conflict free world हो जाएगा, but at least it's not going to go on to that larger scale. ठीक? Chalo, let's come back. Now we're talking about monoism. Now, these are the theories of international law. These are the two very, very basic theories of international law. Iske baad hum do char aur theories padhenge, which are actually a subset of these. But these two are the very basic ones. Now, monoism and dualistic theory. Now, monism basically says that there is a unity of legal systems, meaning thereby they say that the moment there is a municipal law, there is an international law. The fact that it is an international law, it is also automatically going to become a part of municipal law. Now, according to them, there is no difference between international law and municipal law. It is a unity of legal system. They say that there is only one entity. There are no two entities. एक ही entity है, international law and municipal law. तो अगर कुछ चीज international law है, तो वो municipal law का अपने आप automatically it will become a part of municipal law and it will become applicable on the country. And in fact, it says that in case there is a conflict, it will always be international law which is going to supersede, right? So when you're talking of monism theory, their main focus is on the supremacy of international law. कि भाई कोई concept अगर international law का है, then it will automatically become a part of municipal law. There is no need for you to, in fact, create a law for making this binding or making the international law concept applicable on the within the nation state, right? So that is the basic concept behind monism. Municipal, see, I had mentioned it earlier also, Anna. Municipal law इंटरनेशनल लॉ के कॉन्टेक्स्ट में यूज होता है डोमेस्टिक लॉ के लिए. जो हमारी कंट्री के इंटरनल लॉज हैं, दैट इज व्हाट इज नोन एज म्युनिसिपल लॉ. दैट्स अनदर नेम फॉर डोमेस्टिक लॉज, राइट? सो जो हमारे इंडिया के लॉज हैं, हमारे जितने भी आप लोगों ने एक्ट पढ़े हैं, इंडियन पीनल कोड पढ़ा है आपने, अपने इंडियन कॉन्ट्रैक्ट एक्ट पढ़ा है, so all those are our municipal laws. So whatever are the domestic laws are our municipal laws, right? Yeah, municipal laws are your domestic laws. Hasika is saying national, domestic, or international law of a sovereign state. Okay, yes, you can say that. Whatever are our domestic laws, these domestic laws might be pertaining to things which are within our country. They might be pertaining to things which we are doing because there is an international treaty, तो वो international aspect हो जाएगा. But जो भी हमारे अपने laws हैं country के, they are known as your municipal laws. ठीक? So monism बोलता है कि भैया municipal law and international law बराबर है. There is no difference between the two, and they give preference to international law. That is going to supersede if there is a conflict between the two, right? इसके exactly opposite theory is your dualist theory, जो कि बिल्कुल उल्टा बोलते हैं. वो बोलते हैं कि भाई जो municipal law है and international law है, ये two distinct separate legal systems है, right? तो क्योंकि ये two distinct separate legal systems है, इनमें conflict होने का तो कोई सवाल ही नहीं उठता, right? Because they are two separate systems. There is no question of a comparison of them, or there is no question of there being a conflict between them, right? So there is no conflict so far as dualist system is concerned. Now since there is no conflict, so there is no supremacy also. अगर conflict ही नहीं है तो supremacy कहाँ से? Supremacy का issue ही arise नहीं होगा, is the question, right? So it is not that there is no question of them being compared. It's something like, one is an apple and the other is an orange. Can you compare an apple and orange together? No. So that is what an international law as well as municipal law is so far as the dualist theory is concerned. दूसरी चीज क्या बोलती है dualist theory? Now, since they are two separate things, अगर आपको international law, if you want your state to be governed, then the state has the right to choose. They have the freedom to choose whether they want this particular concept of international law to apply to it or not. Only and only if they choose, then will that concept of international law become applicable within the particular nation state. Otherwise, वो applicable नहीं होगा. Right? So here it is, when you are talking about dualist theory, it is only going to be if the state agrees to it, if the state agrees कि भाई ये concept of international law मैंने मानना है. Like when you talk of India, in our country also, which theory do you think we apply? We follow. Do we follow the monism theory or do we follow the dualist theory? Which theory we follow? This is fairly simple. I think obviously we follow the dualist theory, right? We are going to follow the dualist. We follow the dualist theory, right? So all of our international agreements, whenever we sign them, they get only after they are ratified by us will they become applicable. And even after ratification, only and only if we pass a law turning them into a part of our domestic law do we really have anything in place, right? So that is the theory of dualism. Okay, now let's move on to some other theories. ये दो तो आपको वैसे भी पता होंगे because these two had appeared in your paper last year, right? So next are these three other theories of international law. Some of them are actually nothing but a part of the dualist theory only. Okay. Now, the first among them is the delegation theory. Now, what the delegation theory says is it talks about this concept of constitutional rules of international treaties. Now, what it says is that these constitutional rule of international treaties, this is what gives the power to the nation state. Now, this is supposed to be a part of international law. कि भाई ये international law जो है, this gives power to each state. Okay. Then the power to delegate the right to make your own laws regarding whatever is the concept of international law. So if, let's say, there is a particular treaty that you have entered into, if there are two nation states, they've entered into a particular treaty. Delegation theory क्या बोलती है कि एक international law का ही concept है, which is the constitutional rules of international treaties, जो कि state को power देते हैं, which are giving a power to a nation state, whether they want to make it as a part of the domestic law or they do not want to make it as a part of domestic law. Now, this is a very flawed sort of a theory because अब ये constitutional rules of international treaties हैं क्या आखिर? You know, there is no clarity as to what exactly are these. Which school do you think would support this theory? Do you think the monoist school will support this or the dualist school will support this theory? कि भाई एक इंटरनेशनल लॉ का प्रिंसिपल है, that is the constitutional rules of international treaties, which has given the power to the states, which has delegated the powers to the rights to the state to choose whether they want this particular international treaty or international law to be a part of the domestic law or not to be a part of the domestic law. तो ये monoist theory को support करेगा या dualist theory को support करेगा? किसको support करेगा ये? Dualism or monoism? Can anybody guess? On the face of it, it supports dualism, right? Because end of the day, it is giving the choice to the state to choose whether this particular international treaty is going to be a part of the domestic law or not, right? So on the face of it, ऐसा लगता है कि dualism को support करेगा, but actually this theory is something which the people who believe in monism, the scholars who believed in the monoism theory, they are the ones who are the supporters of this constitutional rule of international treaties. Because what they're trying to say is, end of the day, who has given the state the power to choose? International constitutional rules of international treaties. So it is because of this international law concept that the states have been given the choice to choose, right? Otherwise, what this theory is saying is, otherwise the states would not have a choice to choose, but for the fact that the international law has actually given them the authority to choose, right? अब ये exactly constitutional rules of international treaties क्या है, इसके ऊपर ही बड़ा confusion है. That is why this theory is a little iffy. Okay, so this is not really the dualist approach. It might look so, but in actuality, it is actually the monism theory which has the main supporters of this particular delegation theory. Take. So this is delegation theory. I hope this is clear. Next आता है आपका transformation या specific adoption theory. This is nothing but putting your dualist theory into action. ये क्या बोल रहा है? That if there is something which is a part of international law, if you want it to become a part of your domestic law, then it will have to be transformed. It has to be adopted by the state as a rule of law, right? So if it is going to be adopted and transformed as a rule of law, only then will it become a part of your domestic law and it become applicable to the state. So this is nothing but the dualist theory being put into action, right? In fact, जो हमारा Indian Constitution है, Article 253 very specifically talks about this. It says that Parliament has the power to make any laws for the whole or part of territory of India for implementing any treaty, agreement, or convention with any other country or countries or as the decision. So idea being that if you want to implement any treaty agreement or any kind of international agreement, then the Parliament has the power to make law, right? If you want to give effect, then there has to be a law which has to be made, only then effect would be given. So ये क्या कर रहा है? ये बोल रहा है आपको transform करना पड़ेगा या आपको specifically adopt करना पड़ेगा ये international agreement into a legislation passed by the parliament, only and only then can you give effect to this particular thing, right? So ये हो गया आपका transformation या specific adoption theory. I hope this is clear. This is fairly simple. This is exactly what your concept of dualistic is, right? Last theory जो हमारी आज की है, that is known as your harmonization theory. अब हार्मोनाइजेशन थ्योरी क्या है, ये थोड़ी सी दोनों से अलग है. बिकॉज इफ यू लुक एट द मोनिज्म थ्योरी, मोनोइज्म थ्योरी क्या बोलती है कि भाई इंटरनेशनल लॉ ऊपर है, दे हैव एन अपर हैंड. हमने बोला डुअलिस्टिक थ्योरी क्या बोलती है, दैट इट इज गोइंग टू बी द म्युनिसिपल लॉ व्हिच हैज द अपर हैंड, बिकॉज ओनली द म्युनिसिपल लॉ, द स्टेट इज गोइंग टू डिसाइड कि भाई हम इंटरनेशनल लॉ को अडॉप्ट करेंगे या नहीं करेंगे. द हार्मोनाइजेशन थ्योरी पुट्स देम एट एन इक्वल फुटिंग, right? They say that both international law and municipal law जो है वो बराबर है, and in case there is any dispute that whether municipal law should prevail or the international law should prevail, then the courts should try to minimize the dispute between the two. Okay, तो harmonize क्या करेंगे, court decide करेगा that they are trying to minimize between the two, that there should not be any problem. So that is what your harmonization theory is. It's actually, different from your dualistic and monistic approach, because वहां पे आप एक को supreme बोल रहे हो, दूसरे में आप दूसरे को supreme बोल रहे हो. But in harmonization theory, in effect, you are trying to, trying to say that they are both at an equal footing, and you try to achieve your real purpose by trying to ensure कि भाई harmony हो जाए वहां पे. ठीक. So this is so far as your international law is concerned. These are some of the most important features. इसके आगे वो UN के bodies वगैरह होती हैं, all that is also a part of national law, but that is more on the side of legal knowledge rather than understanding the concepts. ठीक है? I hope everybody is clear with what we have done today. Yes? Yes? Chalo, theek hai. If any of you have any doubts, you can put them in the chat box. Otherwise, we can call it a day. Thank you so much. And I hope you guys had a interesting session of miscellaneous laws. Today was the last session. Season finale tha hamara. Ab hamara miscellaneous laws ke liye to at least we are not going to meet. We'll meet again. We'll meet something. We'll do something new. Okay? Take care then. Take care everybody, and bye-bye. And those of you who are new, who are seeing this video for the first time, just to let you know that we have done these sessions on miscellaneous laws. The links would be provided in the description box before. So if you think that you are interested in looking up and you want some clarity on what should be covered under miscellaneous laws for your CLAT preparation, then do look into the videos that we have already done. Okay, and that's about it. Okay, and in fact, so those of you who are new, we are Clat Possible, and these are the various handles where you can find us. And if you feel that you need some help with your preparation for your exam, which is just around the corner, then we are always there to help you out and guide you. Right? Okay. And one more thing, like we were discussing in the beginning, if you have any ideas as to what you want in your next YouTube session, please feel free to put it in the chat box. I got a few suggestions on sample papers, on PYQs, on current legal knowledge, right? So please put in your comments there in the chat box, and maybe we can decide as to next Thursday, what do we want to pick up, right? Chalo then. Thank you so much. Take care, everybody. Have a great evening ahead. Okay, take care. Bye-bye.